see, there's a statement that while you're saying I'm not going to get into any technical questions pursuant to the jury, at least you haven't turned them against you in some way. All right, now the jury panel is going to be selected at some point in time, and when they're all selected and they've got 6 jurors sitting there, the question comes up, well, now, do you accept these jurors as they're impaneled? It's either going to be yes or no. You either are going to accept them or you're not. Well, if you haven't gone into a long voir dire of each and every juror, you're going to prejudice those people if you say, yes, I challenge this array of the jury. I think they're prejudiced against me. Now what you've done is psychologically said, well, now in the beginning you said you weren't going to ask us any questions, and now you're accusing me of being prejudiced against you. And now I'm angry with you. You see, that's a psychological reaction that a juror is going to have. Now remember that this is also a matter of salesmanship. You're trying to sell those 6 people your concept and your ideas. And, as an example, if you don't have a driver's license, and all 6 of these people do have a driver's license, you have an opportunity in 2 ways to show them that a driver's license is an issue that has to be tried by them. It's an issue of fact, not an issue of law. And in order to get an issue of fact before the jury concerning the driver's license, it's a good idea to start informing and educating them by the questions that you're going to use. You want them to know that you're charged without having a driver's license, and you want them to know that you don't have a driver's license, and that's your defense. And I want you people to judge. And they're going to be sitting there going, wow, I can't believe this guy. He comes in here without a driver's license and says he doesn't need one. Okay? Now, how are you going to convince that jury that you're not a person required to have a driver's license now that the jury is sitting there? And this is the difference now between law and fact. Now, our position is that the jury has a right to try the law. But you've got a judge over here and a prosecutor that are going to do everything in their power, and they're going to tell that jury that you do not have a right to try the law, Mr. and Mrs. Juror. You can only be the judges of the facts. All right, so here's the way you add this ringer question. You should ask every juror if he knows and understands jury nullification and jury lawlessness. If that juror says, never heard the words before, now you disqualify the juror for cause. The judge may not throw that juror off for cause, but if he doesn't, remember the Doherty Doctrine of 1970. The presumption of the court is that every citizen knows about jury nullification and knows that he has a right to try the law, and it's for that reason that the judge and the court will not instruct the jury as to their right to try the law. So therefore, a qualification of a juror is, do you know about your right to jury nullification? Don't use the word, your right to try the law, your right to find me innocent in spite of the court's instructions on the law. Just the 2 terms, jury lawlessness and jury nullification. If the fellow says, no, I've never heard the terms before, dismiss for cause, because the Doherty case presumes that he knows, and so does Malloy. If, on the other hand, he says, yes, I do, let the prosecutor over here throw him off. And that's one of the key questions that you're looking for, because if there's a free man sitting on the jury and you bring up the subject, in your case, if you were a prospective juror and the defendant or the lawyer for the defendant said, do you understand jury nullification? Yes. That should be a simple, straightforward yes. That tells him exactly that you're a qualified free man, because only a free man would typically know that he has a right to try the law. Members and subjects, remember, are privileged persons, and privileged persons are acting under privilege, and if they've been acting under privilege all of their life, wouldn't know the answer to that ringer question. When you go through these 84 questions, as you can see, some of them don't apply. It's up to you to go through and ask questions of yourself, and say, well, based upon Kansas and based upon farmers and based upon myself, the charges against me in this particular case, what other questions should I ask that aren't on this course outline, that aren't in this lesson outline of jury questions? You may think of 10 or 15 ringer questions, and in your little group, wherever you may be, you ought to sit down and say, well, what kind of ringer questions could we ask? I've brought up 3 or 4 for you for your consideration that we've used around here, and every time I go into court, I'll sit down 2 or 3 days ahead of time and say, now let's see, the charges here are obstructing and delaying an officer in the performance of his duty. All right. If I'm obstructing and delaying an officer, what questions of fact and law are the people on this jury going to be exposed to? And you see, there's about the 15th move in the chess game. I can't tell you in this lesson what questions to ask the prospective jurors in each and every case. I can only give you the basic outline. You know what the move is when your opponent opens, but after you get into the chess game 10 or 15 moves, you'll have to study it a little bit. So on obstructing and delaying, there's a particular statute. And there may be dictionary definitions. And my state of mind. Now let me show you my state of mind, and I'm going to show you how to argue the law, how to get the law now to the jury. You don't have to take the witness stand in your own defense. But if you do not, you will probably lose before the jury, because almost every jury panel is sitting there saying, he's got to have something to hide and he must be guilty, or he'd take the stand and tell his story. So, in my case, on the big 3, that is the driver's license, registration, and proof of insurance, I take the witness stand. And since I'm representing myself, I'm going to do it in a narrative form. So here's the way I would tell the 6 jurors over here why it is I don't have a driver's license, registration, or proof of insurance. I take the license cases, and remember now, we're telling the jury the law. The jury cannot hear the law from me. They can only hear facts from me. So I can't get up here and say, now ladies and gentlemen of the jury, the reason I'm not guilty is because the Supreme Court in Crandall versus Nevada said, and about the time when you say that the Supreme Court said, the prosecutor's going to jump up and object. The defendant, Your Honor, is trying to instruct the jury as to matters of law, and I object. And the judge will come down on, Mr. Gordon, you cannot instruct the jury concerning matters of law. Now, some of you out there are going to say, amen, wow, man, that's happened to me a dozen times. And they keep shutting me down. That's because you're presenting law to the jury, not facts. So I'd start like this. Well, ladies and gentlemen of the jury, I guess by now you're sitting over there puzzled. And the reason I think you're puzzled is with good cause, because I don't have a driver's license. But I'm not guilty of breaking any law. And the reason that I'm not guilty of breaking any law is because I studied the question of whether or not I should have a driver's license. And in my research and my study, I found some facts. And the facts that I discovered were these. Fact number 1, there's more than one kind of driver on the road. Fact number 2, the Supreme Court of the United States has ruled in a number of cases that not all persons are required to have a driver's license. Fact number 3, most persons are required to have a driver's license. Fact number 4. Now, do you see what you're doing here? You have a right to testify in your own defense. And you have a right to testify as to facts, or to what you believe to be facts, even though you may believe something is true that is not. And when you present your facts to the jury, those facts have to be considered by the jury. I cannot open this book. Fact number 1, in Crandall versus Nevada. No, you cannot do that. But you can tell the jury the facts that you learned from your research. Another fact that I learned was that the states cannot charge a tax for the use of a right-of-way. Another fact that I learned was that a registration fee is a tax. Another fact that I learned was that the fee for a driver's license is not a fee, but rather it is a tax. Another fact that I learned was that the insurance policy is a contract in maritime commerce. Another fact that I learned was that I'm not a person engaged in maritime commerce. Now, I may sit here for a half hour or 45 minutes reciting all of my facts, okay? And there are my facts. And that's my testimony. Now, when I get through reciting all of my facts, and they may be citations from statutes or they may be from various Supreme Court cases. Remember, I haven't instructed the jury on the law. I haven't told them about Thompson versus Smith or the license cases or John Reese's treatise. I haven't said anything about that. I just recited facts. The prosecutor over here, when he put the policeman on the stand, he recited certain facts, didn't he? He said, now, Officer Smedley, did you see George Gordon driving on June 5th, 1983? Yes, I did. And where did you see him driving? He was driving on Americana Boulevard. And what did you observe him do? I observed him drive 45 miles an hour in a 30-mile-an-hour zone. And was that your probable cause for stopping him? Yes, it was. And did you, in fact, stop him? Yes, I did. And did you ask him for a driver's license? Yes, I did. And did Mr. Gordon give you his driver's license? No, he did not. What did Mr. Gordon say? Mr. Gordon said he didn't have a driver's license and that he was driving as a matter of right and that he didn't need a driver's license. Now, those are facts of the case. He's not sitting there saying, and the law says he has to, and Crandall versus Nevada says he has to have a driver's license, and Beard versus Johnson says he has to have insurance, because if he brings up any issues of law, you object. You see, it's fair for both sides. They can't bring up issues of law to the jury, and you can't bring up issues of law or Supreme Court decisions to the jury. Now, you're sitting there saying, but wait a minute, my position is based upon law and the judge won't listen to me. Now we get down to the nitty-gritty, and those are called jury instructions. Now, this is where you're going to win your case with that jury, and you're going to create another reversible error in that long list of reversible errors that you're attempting to create by what's called jury instructions. So if you'll turn over here in your blue book, by this time you should have a blue book, to jury instructions. I'm going to read to you a few instructions, and I'm going to show you how to tell the jury the law as it surrounds your case, because the jury has a right, and you have a right to tell the jury what the law is surrounding this case. Now, there's a good reason for doing all of this, and the reason is that they don't want laymen coming in, citing the Supreme Court and other courts out of context, off point, about things that are not relevant. So when the trial procedure is going on, there have to be relevant issues to this particular case. Only the facts of this particular case. And that's why, as a matter of fact, it's so difficult for lay people, that is the average truck driver, to get an issue of fact before the jury. And the way it's done, the orderly process of the court, is through what's called jury instructions. Can you zero in on this? And let's take a look at a jury instruction and the outline and the format of it. If you'll notice, at the bottom of this jury instruction, there's a citation. This particular jury instruction says, O'Connor versus City of, see, I'm reading it from the back, it's Camp versus Holt, 115 U.S. 620. There's a jury instruction. Now you're sitting there saying, well, gosh, I've never heard the word jury instruction before. All right? Maybe you haven't. But you know every lawyer has, and every lawyer will put jury instructions, and every prosecutor will put jury instructions in on your case, and you probably didn't even know that the prosecutor was putting jury instructions in When you went into court, he had filed them several days before trial, and here's the jury then looking at his jury instructions, and you're going in there without any. And that's about the equivalent of going out on the battlefield, and you're going to fight Goliath, and you walk out there, and you kick him in the shins. You don't have any armor. You don't even have a sling or a smooth stone, and you're going out and do battle with Goliath and then wondering, well, what happened to me when he knocked me down and beat me up? And what happened to you was you never got your theory of the case. You never got the law of the case before the jury. And it's understandable. You didn't know about it. And so today we're going to find out about this key item called the jury instruction. Now I'm going to read this jury instruction. Let's just take this Camp versus Holt as an example. This is a sample jury instruction that I put in a case concerning property rights. And it says, ladies and gentlemen of the jury, you are instructed that the words life, liberty, and property are constitutional terms and are to be taken in their broadest sense. They indicate the three great subdivisions of all civil rights. The term property in this clause embraces all valuable interests which a man may possess outside of himself, and that is to say, outside of his life and liberty. It is not confined to mere technical property, but literally to every species of vested right. Camp versus Holt, 115 U.S. 620. Now here's what makes this jury instruction relevant to your case, or the way you must make this jury instruction relevant to this case. When you took the witness stand and said, I don't have a driver's license, and here are the facts. Fact number one, not all persons are required to have driver's licenses. Okay? Got that? Fact number one, not all persons are required to have driver's licenses. You couldn't open the book and tell the jury the case and the law. When you took the stand, you created the issue. You created a fact. Is that fact substantiated by law? You bet it is. And when I pull out the license cases, see if I've got one here, then I'll get back to this property issue, but since we're pretending that we're in trial here, let's take a look at what a Supreme Court case says. Actually, this isn't a Supreme Court case, but it's close to it. I would put in as a jury instruction in a driver's license case the following words. Ladies and gentlemen of the jury, you are instructed that, and do not put this in quotation marks, and I'll cover that in a moment. But ladies and gentlemen of the jury, you're instructed that the court held that a license to operate an automobile is not property, but is a mere privilege, and therefore a suspension would not deprive the licensee of his property without due process of law. Okay? Let's take a look here. See if we've got another one. Ladies and gentlemen of the jury, you are instructed that the court held that to compel one who used his automobile for his private business and pleasure only to submit to an examination and to take out a license was imposing a burden on one class of citizens in the use of the streets which was not imposed upon others, and such an ordinance was therefore void. Boy, now there's a mouthful. Now picture this. Here you are in court, you don't have a driver's license, and you're trying to convince the jury that you are a person who doesn't need one. Now, you've got to create the facts and testify to the jury the facts that not all persons are required to have a license. So we look at what the court has said, and then that will determine to me what facts I want to testify to relate to the jury. Because once I've testified to that fact, now I can bring in a Supreme Court case or a matter of law in a jury instruction and send it right into the jury, and the judge will instruct the jury that Listen to this. I've got my judge over here now instructing the jury, and he'll say, ladies and gentlemen of the jury, you are instructed that the court has held that to compel one who used his automobile for his private business and pleasure only to submit to an examination and take out a license was imposing a burden on one class of citizens in the use of the streets which was not imposed on the others, and such an ordinance was therefore void. And then the judge will add his own instruction and say, ladies and gentlemen of the jury, you are instructed that if you find that Mr. Gordon was using his automobile for his own private business, he does not need a driver's license. Ladies and gentlemen of the jury, you are instructed that if you find that Mr. Gordon was using his automobile in the use of trade, commerce, business, or industry, he is required to have a driver's license. And the judge will add his own jury instructions based upon the law of the case. And the law of the case are the facts of the case and the law that surrounds the facts. And in this case, you see, if a person is using the automobile for his own private use, he's not required to have a driver's license. But if he's using the automobile for trade, commerce, business, or industry, or for hire on the roads, then he is required to have a driver's license. Let's take a look at a couple more of these and show you what facts I would want to testify to, or what facts I would want witnesses to testify to, what facts I want the police officer to testify to, so that I can use those within the meaning of this law, within what the court has said. For instance, it was further said that the use of a motor vehicle is frequently the true source of a man's ability to earn a livelihood, and to deprive him of his privilege unnecessarily is not a reasonable police regulation. Okay, now let's see now. What could we do? What questions could we ask of the policeman on the stand that would create for me the facts necessary to put this particular Supreme Court citation in as a jury instruction? Is it a reasonable police regulation? So let's, right at the scene of the crime, with this information in our mind, oh, officer, I want you to know that I'm not operating this automobile in trade, commerce, business, or industry. Do you understand that? Now, picture this. You're out here alongside the road, and the policeman has just stopped you, and he's walked up to the window, and he says, now I want to see your driver's license, registration, and proof of insurance. And the first words out of your mouth are, of course, well, in that case, is this a custodial interrogation? And if so, do you have a Fourth Amendment warrant? And what is your probable cause? And I demand counsel present. I mean, you're going to go through your lines, right? This goes back to lesson 2. But once you get out of the car and you enter some dialogue, if you want that policeman to testify that you're not using this road as a matter of trade, commerce, business, or industry, then you better tell him, because, officer, I'm not using this road for trade, commerce, business, or industry, and the passenger riding with me is not riding for profit or gain, and he's not paying me anything. Now, why am I doing that right at the scene of the crime? I'm doing that because when I know that 3 months from now, when I get him on the witness stand, I'm going to ask him those factual questions, and they'll be questions like this. Let's see. Officer Smedley, at the time you asked Defendant Gordon for his driver's license, did he say anything to you? Yes, he did. Did he say to you that he was operating a taxi cab? Oh, no. Did he say to you that he was operating a business on the streets? No, I don't think so. Well then, Officer Smedley, did Mr. Gordon say to you plainly in these words, I am not operating this automobile for trade, commerce, business, or industry, and I'm not doing it for profit or gain? Did he use those words or words similar to those? Yeah, I think he did. Well then, he told you plainly then that he was a person not required to have a driver's license, didn't he? Well, yeah, he said that. Well then, why did you give him a ticket? Well, because the law says that he has to have a license. The law then, to your knowledge, requires that. Is that correct? Yes. That is the statute. That is Idaho Code 49-317 requires Mr. Gordon to have a license. To your knowledge, that's the information you have. Yes. Do you know of any other laws that would exempt Mr. Gordon from having a driver's license? No. And that's why you gave him a ticket. Is that correct? Yes. Now what have you done? You've established some facts. The officer believes that Mr. Gordon needs a driver's license, and he's written the ticket in good faith. He fully believed that Idaho Code 49-317 was the statute in question. But the facts that you've gotten from him would grant you then this jury instruction, that it was further said that the use of a motor vehicle is frequently the true source of a man's ability to earn a livelihood, and to deprive him of this privilege unnecessarily is not a reasonable police regulation. You said that you weren't using the vehicle for your livelihood. Now, let's turn over here. Oh, and down here at the bottom, the court held that to compel one who used his automobile for his private business. You've established from Officer Smedley that you were using it for your private business. And you need to make the statement, Officer Smedley, I'm using this car for my private business in the ordinary course of my life. I'm not using it in any extraordinary way. Now, once his facts, I believe Mr. Gordon needs the driver's license and is required to have it, and my facts, I've done research and I found that I'm a person who's not required to have it. While I can't testify to these, I can't sit here and say, ladies and gentlemen of the jury, I found out in Thompson versus Smith in 1930 that the court held to compel. See, if I try to tell the jury that, I'm going to be shut down in a heartbeat, and threatened and admonished, and I'm going to get my feelings hurt just like you have and a lot of other people, and say, whoops, wait a minute, Mr. Gordon, you cannot instruct the jury on matters of law. So the way I do it is this. Once I've gotten Smedley's testimony and my testimony and I've established these facts, now is a jury instruction. I instruct the jury. Ladies and gentlemen of the jury, you're instructed that the court held that to compel one who used his automobile for his private business and pleasure only to submit to an examination and to take out a license was imposing a burden on a class of citizens in the use of the streets which was not imposed upon others, and such an ordinance was therefore void. Okay? You've instructed the jury to exactly what you wanted to instruct that jury sitting over here to. And yet, you've done it in writing, where you couldn't do it verbally or you couldn't do it in testimony. Now, do you see the difference? See how easy that is? All right, let's take a look then at this case called Camp versus Holt. Just take a look at this. These are jury instructions that I've used concerning property. I could not tell the jury about Camp versus Holt. What I had to do in my legal research was, when I found Camp versus Holt, I had to tailor my testimony and the testimony of my witnesses and the testimony of the government's witnesses to fit this Camp versus Holt doctrine. Once I did that, once I'm aware of the law, I create the facts at the scene of the crime. I create the testimony in the courtroom. I create the cross-examination from the witnesses involved. And that's the way you get the law to the jury. Now, it seems simple. Let's practice a little bit and see what it is that you have to do to get a jury instruction in and when you file it. Jury instructions have to be in writing, and they have to be in 4 parts. The jury will not see the words Camp versus Holt, 115 U.S. 620. So here's the way you write it up. Let's just take as an example, and let's just act it out and think it through. You've talked about the driver's license. I want to tell the jury about a case called Smith versus Thompson in 1930 that says, I don't need a driver's license if I'm not acting in trade, commerce, business, or industry. Now, how do I do that? I know about the Thompson case. At the scene of the crime, I set the policeman up by telling him I don't have a license and I'm not required to. I told him I'm using my car in the ordinary course of my business for pleasure and I'm not engaged in any profit or gain. I got him on the witness stand and I got him to testify to that, and I testified to it. Now the jury is sitting over here a little confused, and I need to tell the jury about this particular citation. I want them to see that. And so the way I do it is I write it up in 4 parts. And the way that's going to look is this. Now let's zoom in on this jury instruction. Number 1, you'll notice at the bottom, there's no jury instruction. Down at the bottom, it has no citation. It does not say Camp versus Holt. The jury cannot see the citation. As far as they know, when they're looking at a jury instruction, it's that trial judge that gave them this instruction. But in reality, it's the Supreme Court of the United States that's giving this instruction. Now let's take a look at this jury instruction that does have the citation at the bottom. Notice this is the identical wording. It's drawn right out of the Supreme Court case called Camp versus Holt, 115 U.S. 620. And the judge is going to get this copy. Your opponent, the prosecutor, is going to get a copy, and you're going to get a copy. All right, now mark this down in your notes. Now get this straight because it's crucial to you. Your jury instructions won't be accepted unless they're sent in timely. You see, about 5 days prior to trial, the judge has to see your written jury instructions. You haven't even gone to trial yet. You haven't laid out your theory of the case to the jury. But by your motions, you see, from lesson 13 and 14, and we got up to lesson 20, and we went through the motion hearings, and when it was all said and done, we got our theory of the case across to our opponent, the prosecutor, and across to the judge. He knows that when you go into court, based upon your motions and arguments, that you've stipulated to the facts that you don't have a driver's license. All right? Now you come in with the jury instructions in the state of Idaho 5 days prior to trial, and you file these with the court. What I do is I go across the street and I have them stamped in just like a motion. And then I walk over to the judge and I give him a copy of all of my jury instructions. Can you imagine this? I walked into the judge and I dropped a stack of paper on him this thick with all kinds of Supreme Court quotations and standard jury instructions, etc. 5 days before trial, he knows what my jury instructions are going to be. My opponent knows what my jury instructions are going to be. And so the day before trial, the judge will typically call for a pre-trial conference. And during the pre-trial conference, you go in and you talk about your procedure in the case. Any jury instruction that you've submitted prior to trial is not necessarily going to be admitted as a jury instruction to the jury. Because what happens if you walked in and you forgot to cross-examine the policeman and you forgot to take the stand and you didn't show that you were not by fact. Now, you didn't show these facts, that you're not a person who was operating in trade, commerce, business, or industry. Then that jury instruction wouldn't be relevant to the jury because there are no facts that say you are a person who is operating your car in private business, that you were operating it in the ordinary course of events. If you don't have this license cases book, you should send for it and make yourself, or at least familiarize yourself with the subject matter of this thing of the right to drive, whether or not you're interested in that. Maybe you're a truck driver and you need a driver's license, or you're a taxi cab driver and you need a driver's license. As I've said, I'm not here to tell everyone to throw their driver's license away. I'm here to tell you that not everyone is required to have a driver's license. Not everyone pays income tax because not everyone has income. But all of those who do have income must pay the income tax. And all those who do use the roads for trade, commerce, business, or industry must have the driver's license. And so you can't come in with a jury instruction then, can you? And tell the jury that a person doesn't need a driver's license if he's not engaged in trade, commerce, business, or industry, and that's a Supreme Court case or that's a jury instruction from this trial judge if you haven't established a fact surrounding the law of that case or a law of the case that surrounds that fact. And so you create the facts out at the scene of the crime. You create the facts in the jailhouse. You create the facts by your standard of living or your code of living, the way you live your life every day. And as an example, if you're hauling people for private profit some of the time, then you're going to need a driver's license all of the time. An example of that would be, let's say, the prosecutor could bring into court a person who would testify like this. And Mr. Jones, do you know the defendant, Mr. Gordon? Yes. And have you ever ridden with Mr. Gordon in a motor vehicle? Yes, I have. And would you tell the jury in what capacity did you ride with Mr. Gordon? Well, he took me out to the airport. I say, and did you pay him for that? Yes, I did. I paid him $5. And did he tell you that he was going to charge you $5 before you got into the car? Yes, he did. And how did you happen to get a ride with Mr. Gordon? Oh, Mr. Gordon has a stand on Chinden Boulevard, and it says limousine service. I see. And is that open to the public? Well, yes, it is. I believe it is. And how did you avail yourself of Mr. Gordon's service? Well, there's a bench there, and I just sat there, and it said that at 1:30 a limousine would come by, and at about 1:30 the limousine came by, and Mr. Gordon took $5 from me and hauled me out to the airport. Okay. And so Mr. Gordon did this then as a matter of commerce. Is that correct? Well, yes, I paid him for his services. Now do you see where they've got you? In other words, your very jury instruction will hang you now because you've got a fact. The prosecutor has brought a fact in that you were engaged for profit and gain. And Smith versus Thompson says that if you're engaged in traffic for profit or gain, you have to have a driver's license. So it's imperative that you show by the facts that you're not that person. Now, when you get into court then, your jury instructions are facts. And so as you're going through your witnesses, you question the witnesses based upon the jury instructions that you want to get in. So you go through this jury instruction, which says, Camp versus Holt, that you're instructed that the words life, liberty, and property are constitutional terms. Okay, so here's a fact. You take the stand and you say, a fact that I contend for, ladies and gentlemen, that the words life, liberty, and property are constitutional terms. I believe that. And I have conducted myself accordingly. There's the fact, and here's the jury instruction from Kemp versus Holt, and the Supreme Court of the United States has said those very words, and you've testified that you believe that. You might now put an expert witness on the witness stand, and that could be a lawyer. And a lawyer is an expert witness, and he can testify as to what the law means, at least in his opinion, his professional opinion. Let's try this. You put a lawyer on the witness stand, and you say, now, Mr. Jones, would you tell the jury what your position is or what your occupation is? Yes, I'm a lawyer. And how long have you been a lawyer? I've been a lawyer for 25 years. And what branch of law do you specialize in? Constitutional law and criminal practice. And have you read a number of Supreme Court cases? Yes, I have. Are you familiar with the Supreme Court's decisions on various topics? Yes, I am. Do you know how to research? Yes, I do. Do you understand shepherdizing? You bet. And you're going to ask him all of these qualifying questions that establish him as being an expert witness. And then you ask him the questions, have you studied the Constitution? Yes, I have. Have you read a number of Supreme Court decisions pursuant to the Constitution of the United States? Yes, I have. And will you tell us, in your professional opinion, what the words life, liberty, and property mean to you? And he'll answer, they are constitutional terms to be taken in their broadest sense. You see, he can testify to that and tell the jury because he's a professional. you could get a law professor to do the same thing. All right, now let's cover the physical aspect then of getting this thing in. Now we've talked about qualifying it. You need 4 to 5 copies of this depending upon your rules. I use 5 copies, and here's the way I do it. First of all, I type it up with the citation at the bottom of the page. Let's zero in on this and take a look. Here's the citation. There's the quotation. That citation and quotation goes to the judge. It goes into the file folder because I've filed it as a motion. It goes to my adversary and it goes in my file folder. And the 5th copy I cover up like this. And I run it off for the benefit of the jury. Now there's your 5 copies. A copy is filed and stamped into your file folder, each and every one of them. And then you go over to the judge and you drop a stack with the citation at the bottom for the judge, and another stack without the citation so that the judge can give those physically to the jury foreman, and the jury foreman will take it into deliberations and read all of your instructions to the jury. All right? The prosecutor, or in a civil case, your opponent, he has a stack just like this. Then you have a stack, and when you go through your case, you use that stack of jury instructions as your notices, your notations, your notes, and you go through and you make certain. And then you've got your yellow pad over here, and you've taken notes on your yellow pad, and you've said, now, what is it I want to ask Officer Smedley? Jury instruction number 1, 6, 11, 14, 21, and 27 relate to testimony that I need to get from Officer Smedley. And so it says jury instruction number 1, number 2, number 3, number 4. In other words, you number your jury instructions. And that way, when you're asking Officer Smedley about jury instruction number 1, you've got jury instruction number 1 right here. And at the scene of the crime, you didn't have a driver's license, and you told him, Officer, I do not have a driver's license. Officer, I am not engaged in trade, commerce, business, or industry. Officer, this is my own private business. There's 3 facts. And pursuant to this Supreme Court case, you've got those 3 facts on the record. Now, the jury is the judge of the facts. And so when the jury goes in, the trial judge gives them that Supreme Court citation, and into the jury room they go with the written instruction right out of your mouth.